Hello, I'm Mark Sullivan. My talk today is entitled, Honey, I think we've shrunk the kids' inheritances. Some tips for advising and protecting parents in the context of possible family law property settlement disputes involving their children. I've been in lockdown on 3 occasions in 2021. Mullane and Lindsay are taking no chances. This is why we're presenting my paper as a podcast rather than face-to-face. I look forward to the opportunity to mix socially with you and members of our family law and commercial law teams when the time is right. Now, parents are generous. They give money and transfer property to their children, often without enough thought to the consequences of what might happen if their children's relationship with their spouses or their partners breaks down at some future time. In 2019, the 5th largest money lender in Australia was the Bank of Mum and Dad, lending a whopping $90 billion in that calendar year. The recent surge in home prices has been accompanied by an even greater increase in the support of first home buyers by their parents. 60% of first home buyers are reported to be receiving financial assistance from parents. I wonder how much of this assistance has been documented to protect the parents and their children if there is a relationship bust-up. I'll be discussing some of the issues for parents and how you, as their trusted financial advisor, can help them. For some context, when marriages or de facto relationships break down, it's generally necessary to disentangle the parties' financial affairs by way of a property settlement. Property settlements are generally all about money and trying to reach a cost-effective outcome through negotiation, mediation, arbitration, and if they're unsuccessful, litigation. What makes each of them different from the other is generally the mix of personalities and experiences of the related parties and the availability of evidence to support competing claims in the event of a dispute. If you are a parent and you've transferred property to a child prior to their relationship breakdown, you'll generally want that property to remain as a benefit to your child after their property settlement. If you loaned money to them, you'll want to ensure that money is repaid to you and not regarded as property for division with your child's former partner or spouse. You may need it for your own purposes or to have the freedom to reloan it again at some future time to your child. In my experience, parents have rued the day they did not take precautions against the consequences of a relationship breakdown before being generous to their children. This is usually because the time to be prudent and businesslike is when the money is being loaned or the property gifted. It becomes complicated and messy trying to remedy the issue when there's a relationship breakup. It should also come as no surprise, but memories fade when there are disputes about money. It's a grievance to many people that money they intended to benefit their own child is dissipated in a family law property settlement. Few parents want to become embroiled in their children's family law property settlement disputes when there's a breakdown. They may be close to their child's partner, there are likely to be grandchildren, and divisive litigation will almost certainly impact on their relationship with their grandchildren. There's also the expense of litigation with its emotional and financial distress, which will unsettle even the strongest of retirement plans. Although it can be awkward and might give children and their spouses some discomfort, parents owe it to themselves and to their children to act in a business-like manner when making gifts or loans to their children. It doesn't mean that they lack confidence or optimism about the longevity of their children's relationships or their choice of spouse. It's simply the right thing to do. It's an issue of experience over hope. Now, here's some information about property settlements generally. Currently, there's no presumption of equality when determining a property settlement. The family law courts have a wide discretion to make such orders about property that they consider to be just and equitable in all of the circumstances of the case. It should not be palm tree justice. Decisions need to be based upon principle, but reasonable minds can disagree on outcomes on the same set of facts. It's not a precise science or an audit. Whilst the facts in every case are almost always different, outcomes can be influenced by the evidence that is available to support arguments, which is why I emphasise the need for documentation when parents make gifts or loans to their children. The courts and lawyers advising on property settlement undertake a 5-step process when determining what should be a fair and equitable property settlement outcome. Firstly, we ask, is it just and equitable to make any order for property adjustment, Or should the existing legal ownership structures remain intact? Examples where no adjustment may be likely include short relationships where there has been little, if any, commingling of finance and no kids, and the parties have been clear to use formal or informal written or oral agreements to govern their respective interests in property and the manner in which they regulate their financial affairs. Keeping property in a child's name rather than joint names can be an advantage, as will a financial agreement, be it binding or otherwise, that sets out the stated assumptions of the parties and how they intend to deal with the property. Secondly, we identify and value the pie, which is the asset pool. This includes identifying the legal and equitable interests of the parties in property, their liabilities and superannuation entitlements, and we attribute a value to the property pool. The relevant date of the valuation will be the time the parties are negotiating a settlement, or are in court or at mediation. And so this includes property acquired after separation. There can be more than one pool, so a global or an asset-by-asset approach can be adopted. There have been many hard-fought contests over defining what should be in the pool. In the context of today's discussion, there are often many disputes about properties in which parents claim they have a legal or an equitable interest, which they demand should not be included in the pool for division. And whether loans to children are genuine and must therefore be repaid before there's a division of the remaining property between the parties. Thirdly, we assess the homemaking, parenting, direct and indirect financial and non-financial contributions of the parties to the acquisition and conservation of the parties' property in an holistic way rather than undertaking an audit. This includes identifying the direct and indirect financial contributions made by parents on a child's behalf. It's well settled that the length of a relationship has a significant impact on how early capital contributions should be viewed in assessing the totality of a party's contributions. The longer the duration of a marriage or relationship, the more likely it is that the proportionality of the original contribution is reduced. It's likely that there will be later factors of significance to reduce the weight of the original contributions. If proper steps have not been taken to preserve evidence from generous parents of financial gifts or forgiven loans over time, little weight may be attributed to them. And this is to the disadvantage of the parents and their child, especially in shorter relationships. Fourthly, we undertake an evaluation of the future needs of the parties involving a shopping list of matters, including a comparison of each party's assets, liabilities, financial resources and income earning capacity. The need to provide care for the children, whether one or both parties have suffered a diminution in their employment capacity as a result of the relationship, and the age and state of health of each of the parties. The need to protect a party who wishes to continue their role as a parent, the financial circumstances of any new partner, any child support that is paid or payable, and any other fact or circumstance which, in the opinion of the court, the justice of the case requires to be taken into account. There may be an adjustment of property at this third stage which undermines the significance of gifts from parents or an inheritance received late in the relationship. Finally, consideration is given to the distribution mix of property between the parties and whether the final orders proposed are just and equitable. It's difficult to undertake a property settlement assessment without there being an exchange of relevant information, known as disclosure. Each party has an obligation to provide complete details of their financial circumstances and any property in which they have an interest. The court has the power to make an order going beyond the identified property if there is sufficient evidence to support a finding that a party has not made full disclosure of their assets. If full and frank disclosure is not made by a party, then the court may order that party pay the legal costs associated with that non-disclosure. We've presented papers in the past on the importance of financial disclosure and provided tips to accountants and financial planners about how they and family lawyers can work together to the benefit of our mutual clients. Suffice to say for this topic, disclosure is good. The general thrust of my tips will be that there must be records and evidence of the generosity of parents. These records should be retained by parents and made available to their children during a property settlement dispute. The disclosure of such documents will give strength to arguments in support of their children's claim and encourage an early settlement. I'm going to talk about gifts. Gifts from parents before or during a relationship or after the relationship has ceased, and prior to property settlement are generally considered to be an indirect financial contribution made on behalf of their child. They will form part of the asset pool for distribution. You cannot quarantine them and ask for them to be repaid to a parent. There may be a dispute as to whether such gifts were even made and for whom they are intended. Their weight in the overall consideration of what is a just and equitable settlement may fluctuate from case to case. It has been long established in family law that a gift is to be treated as a contribution on behalf of the person who is the relative of the donor, unless there is evidence of the donor's intentions to the contrary. So parents need to be specific when making a substantial gift, that the gift is intended for the benefit of their child. Whilst being able to argue that a gift from one's parents is an indirect contribution is a good fallback position in a property settlement dispute, it means that a gift from a parent will not be attributed full weight or value in most circumstances, as the weight of such gifts can be offset by the myriad of related contributions of the parties. For instance, a large gift of money to help buy a home early in the relationship might be offset by later parenting contributions, or changes in employment capacity or health, or a disparity in each party's future financial needs. Further, in the absence of evidence as to the quantum of the gift and the intention of the donor, there is scope for an aggrieved former son or daughter-in-law to undermine the significance of the gift, so that the child of the donor is unlikely to receive much benefit of the gift in the final wash-up. There's long-standing authority to the effect that when money or property is provided by a parent to a child, and it's unclear whether it was intended as a loan or a gift, then it will be treated as a gift and not as a loan repayable from the asset pool. Generally, therefore, giving documented loans to children is better than giving gifts. Transferring property to children or co-owning property with children can be a minefield when determining the legal and equitable interests of the parties in the property, and it can raise issues about express resulting in constructive trusts. It's not uncommon for there to be disputes about whether a real estate property should be included in the pool for adjustment because there's confusion about who owns it. The property may be registered in the name of the parents and a child in different proportions. This may have been for historical reasons, such as to assist a child get a loan, or an inducement to a child to get into the property market, or to hide assets, or the child may own their proportion on trust for the parents who have contributed all or most of the purchase price. In a property settlement, the child may contend that they hold their proportional interest in property on trust for the parents, or that the certificate of title correctly identifies the ownership of the property. The estranged former partner or spouse, however, will often deny this and contend that the child has a beneficial interest in the property as per their legal registered interest on the certificate of title, or that it is in fact the parents who are holding their interest in the property on trust for their child, and the whole of the property should be in the pool and up for grabs for division. In the absence of documentation, the parents will need to give detailed oral evidence of conversations had many years ago. Bank statements, if available, may not tell the full story, and it's possible that there may be very different recollections of the timing and content of significant events. If it is intended that a child hold property on trust for the parents, then an express trust needs to be declared and evidenced by a deed of trust. In the absence of a written deed of trust, the requirements for the creation of an express trust include whether there is language or conduct showing a clear intention to immediately create a trust, certainty as to the subject matter, and clarity about the purpose of the trust and the extent of the benefit. In the absence of any writing containing the terms of any trust made either at the time of or subsequent to the purchase of a property, an express trust is unlikely to be found, and the child's registered interest in the property is likely to remain in the matrimonial pool for adjustment. If the parents have funded the purchase of the property, they might argue in the alternative to an express trust that although a proportion of the property is registered in their child's name, there is a resulting trust in their favour, which is proportionate to their financial contribution to the overall purchase price. The parents must, however, have evidence of their financial contribution and their intention at the time of acquisition if they if they are to be successful in a claim of resulting trust, and in rebutting the presumption that the beneficial interest was intended to be conferred by them on their child as a gift. Evidence by the parents as to their intentions at the time of the transaction is admissible, but the courts treat that evidence with some caution, as it is the evidence of an interested party. It is better for parents to prove the subjective intention when making the original purchase payments by evidence of their contemporaneous statements of intention in loan agreements, deeds and trusts, or emails and correspondence, and by evidence of other relevant surrounding circumstances, such as tax returns. Issues of ownership of legal and equitable interests in property are often further complicated by claims by an estranged former partner or spouse that the parents held their share in the jointly owned property on behalf of the child and their spouse by way of a constructive trust. The estranged former partner or spouse might then argue that they made indirect non-financial contributions towards the care and maintenance of property. Further, there were statements from parents that they could reside in the property for life, or it would become theirs, and they would be promised it in their will. They always referred to the property as theirs, and they were encouraged by the parents to do renovations and improvements for their own comfort. They made gratuitous payments on rates and utilities. They acted to their disadvantage and did not look elsewhere for another home to buy, and so now it would be unconscionable for the parents to assert that they own the property, not the child and the spouse. Both parents should be alerted to the risks of constructive trusts arising and not make such promises to children. Sometimes parents will assist their child by paying their mortgage expenses. It may start off as an assistance during a time of unemployment for their child and continue for some years. Some parents might think this entitles them to an interest in the property or some right for repayment from the child. But the reality is, the parents are simply making a contribution to the release of their child's mortgage obligation. And, in the absence of a loan agreement with their child and spouse, these payments will be regarded as gifts and treated as indirect contributions by the child. These disputes are always messy, and the parents and the child will often need different lawyers representing them. The expense and distress and ongoing delays of litigation will be considerable and avoidable. Some tips. When at peace, prepare for war. If it is intended that a child shall hold property on trust for the parents, then an express deed of trust needs to be declared. Each party needs to be separately represented or have the opportunity of independent advice. The parents and the children should stick to the trust agreement and store it in a safe place. Payment of a deposit on a home for a child in the absence of a declaration of trust is better than making payments on the mortgage. If it is intended that property transferred or advanced is by way of gift, parents should keep a chronology setting out when gifts are made. This should be supported by corroborating documents preserved in a safe place. Email chains and bank statements, for instance. In circumstances where the gifts are material, the parents need to clearly express to the child and their partner or spouse that it is their intention that their child be the person whom they primarily wish to benefit by the gift. It will follow that their son or daughter-in-law will receive a secondary benefit. If the gift is intended to be conditional, such as it must be used to purchase an interest in a home, not on lifestyle, or will be repayable if their relationship breaks down within a certain period of time, then there needs to be a statement in writing setting out the conditions, such as in a deed of gift. Alternatively, contemporaneous notes about the conversations between the relevant parties, including what was said, by whom, and the place of those conversations, need to be retained. It is possible to enter into a deed of gift which include recitals stating the parents' intentions and an acknowledgement by their child's spouse or partner that they are aware of and understand the parents' intentions to benefit their child, and a desire that the benefits continue to that child even if the relationship between the child and their spouse should cease. Loans. Liabilities incurred during the child's relationship and prior to separation would generally be considered a liability of the relationship. They should be added to the balance sheet as a liability, and there will be an expectation that they will be repaid from the party's property as part of the settlement. It's more advantageous to parents to lend money rather than give money if they wish to see the full benefit flow to the child on a relationship breakup. The likelihood of loans being included as a liability in the property settlement of their child is increased if there is evidence of the loan from the parents, as it will be arguable that the justice and equity of the case demands that the liability be repaid, as this was the intention of the child and their spouse also. It's possible that a loan from a parent may not be included as a debt for repayment if the alleged loan is vague or uncertain or unlikely to be enforced. Such loans will be treated in the same way as if they were a gift. The manner in which a particular liability should be treated is ultimately dependent upon the nature of the liability, the circumstances surrounding the liability, and the dictates of justice and equity shaped by those two things. It has often been argued by a child's former spouse or partner that money advanced by their parents-in-law for the purchase of a home or stamp duty and legal expenses on its purchase was intended to be a gift to both parties. The arguments were, however, easily undermined when the loan was evidenced by loan documents and a mortgage was registered over the title to the property. And there was a regular reminder that the loan will be enforced, and a notional payment was made on a regular basis in reduction of the loan. Some tips in relation to loans. In the absence of documentation, the conduct of the parties, including whether any payments were made by the borrower, will be important. It's crucial, therefore, that records of advances, repayments, and any security offered be kept. Our preference, however, is for loans to be formally documented and the advance be from both parents should one die. It's important that parents obtain documented security for the loan where possible. The lack of security may be fatal to the question of the enforceability of the loan and its inclusion in a balance sheet. It may be a charge over a motor vehicle or a mortgage over a property. A registered mortgage provides an interest at law and may give priority over other interests. Parents and the child need to be transparent in their intentions. Ideally, they should also involve the child's spouse in discussions. This will measure expectations and help to reduce the risk of potential litigation. It will assist the argument that both parties should bear responsibility for the liability in circumstances where they are both aware of the liability. Documentation improves the parents and their child's position for the purposes of negotiation. The loan agreement should contain a written and express intention for the money to be repaid. It must be clear in its intentions and considered in the context of how will the loan be interpreted in the event of a breakdown of the child's relationship. And it must include some of the following. It's the intention of all parties to create legal relations. A full description of each of the parties and their relationship to one another. The terms of the loan, including the amount being loaned, and an acknowledgement of the receipt of the loan by the borrower. Records of the advance and any repayments should be retained. A history of repayments will be evidence that the loan is enforceable. Details of whether the repayments are interest only on a weekly or monthly basis, principal and interest on a weekly or monthly basis, the full amount to be payable at the end of the term, or whether the full amount is payable within so many days of demand. Any security to be offered in respect to the loan, any right to place a caveat over the title to the property, including a consent to allowing such a caveat to be registered. Details of the interest rate, if any. If no interest rate is to be charged, then a statement to the effect that the interest-free provision is made to the benefit of their child. Whether default interest is charged for late or non-payment. If the loan advances are material, the borrower should seek independent advice and acknowledge receipt of the loan and receipt of that independent legal advice. Section 14(1)(a) of the Limitation Act provides that a cause of action founded on a contract is not maintainable if it is brought after the expiration of the limitation period of 6 years, running from the date the cause of action first accrues to the claimant. This is, however, subject to Section 54 of the Limitation Act, which provides that if a cause of action is confirmed by the person against whom the cause of action lies before the expiration of the limitation period, the limitation period will restart from the date of confirmation. So in the absence of a deed, parents should review the loan prior to the end of a 6-year period and give written confirmation before the end of the 6-year period that the loan is in fact still repayable, so as to restart the limitation period for the right of enforcement and so as to avoid the parents becoming statutorily barred from enforcing the loan. This confirmation about the enforceability of the loan should be preserved. I've seen incidents when loan documents were established for the purchase of a first home, but were not re-documented upon the sale of the first home and the purchase of a second home. Parents should ensure that they review loan documentation and enter into new loan agreements in respect to any new property if the sale proceeds from the first home are rolled over into the second home. Consideration should also be given as to what happens on death. Common ways of treating such loans on death include a complete forgiveness of the debt under the will. The loan will then be extinguished. This may not provide the protection parents want to give in respect to that money. They should then ensure that if the debt has been in both names, there is a supporting statutory declaration to the effect that it is the intention of the testator to primarily benefit their child rather than their child's spouse. Depending upon the quantum of the debt or the loan, a testator might establish a testamentary trust in their will with the child and grandchildren as a beneficiary. This will reinforce the intention of the testator that it is to benefit their child rather than the in-law. Beneficiary loan accounts are sometimes an issue as well. Any credit beneficiary loan accounts in a family trust are an asset of the beneficiary and will be included on the balance sheet. So, the balance of beneficiary loan accounts should be reviewed and distributed by matching cash payments regularly. It's important to ensure that their parents, in their capacity as trustees of the family trust, do not create beneficiary loan accounts in favour of beneficiaries with a high level of exposure to relationship breakdown. Different strategies need to be adopted for different children depending on their circumstances. My conclusion: it's not been my intention to be the Grinch, but simply to pass on lessons learned from many other parents' bad experiences. If parents wish to ensure that their children receive the optimal benefit from parental generosity, and it endures, then they need to factor in what might happen if their child is in a relationship breakdown and take precautionary steps. These involve transparency in their intentions and motivations, documentation and preservation of records should they ever be needed. Stay well. Thank you.